welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Dr. Reid Krell, an instructor in the University of Alabama Department of Political Science. We will discuss his article, The Power of Jury Instructions, Evidence from EEOC Cases. So welcome to the show, Reid.
Thank you. I'm delighted to be here, Brian. It's great to be here. I should warn you, I'm talking to you from my home, and so we may get interrupted by one or more cats.
Not a problem. My cat has been locked out, but there are more than one episode has featured some meowing in the background, so that's totally par for the course. So I'm really glad to have you on the show, Reid, because I really found this paper fascinating, really well done, and weirdly counterintuitive in a way that I really like. But I think for listeners to understand why that is, they need to understand a little bit of the background of what you're talking about. So, I wonder if you could talk about sort of what jury instructions are, where they come from, and sort of what role they play in civil litigation.
Yeah, so jury instructions are more or less exactly what it says on the tin, right? They are instructions to the jury on how a jury should analyze the evidence that's been presented to them. So, we're all familiar with the concept of a jury trial being preserved under the Seventh Amendment. Not going to go down the rabbit hole of what that means, but we know that in civil litigation, you have the right to ask for a trial in front of a jury as opposed to a trial in front of a judge under certain circumstances. When you're in front of a jury, that's, to be somewhat flippant, a friend of mine likes to say that, a trial by jury consists of a trial in front of 12 people too dumb to get out of jury duty. I don't know that I necessarily agree with that, but it sort of captures, I think, the problem that you're dealing with a bunch of people who don't know anything about your case. In fact, if someone shows up who does know about your case, they may get thrown out, right? We want, for whatever reason, we want juries that are blank slates when they show up. And so they have to be told how to decide the case. And that's what jury instructions do, is they are mechanisms whereby the court tells the jury what the law is. And they'll say, in order to find for the plaintiff, you have to find that the plaintiff has proved X, Y, and Z, right? And what that X, Y, and Z is differs from case to case. It's specific to the types of claim that you're presenting. Jury instructions are usually created very late in the process, right on the eve of trial, and there's usually an attempt by the parties to try and reach some sort of agreement on at least some instructions, but frequently there isn't agreement. They certainly try. And the judge has to decide what the right jury instruction is. What is a correct statement of law? In order to make this easy, a lot of jurisdictions, both states and federal courts of appeals, publish books of model jury instructions that can be used across any type of case that fits where that issue arises. So you may have an instruction related to what is and is not evidence, right? That's going to be an issue in almost every case. Lawyers' statements aren't evidence, and so there's a model instruction for that issue. You may have an issue related to the standard of care, like in a medical malpractice case. There may be a model instruction as to what is the standard of care in these types of cases. And if a judge gives the model instruction, whatever the verdict is can't be reversed on the basis of that instruction. Model instructions are correct statements of the law. They've been approved by the appropriate reviewing court. But sometimes judges deviate from those model instructions. And really what I'm looking at is what are the incentives and the pressures that might lead litigants to push for deviations from model instructions and for judges to grant them.
So in your paper, you recognize that there's been some limited previous scholarship on jury instructions in the same sort of empirical vein that you're proceeding on, but your perspective or the sort of the thesis of your paper seems really different from some of that other work, or you're asking really different questions. I wonder if you could just briefly sort of talk a little bit about the state of the field and sort of how your intervention differs from what other scholars have done.
Yeah. I am really hesitant to say that there's nothing out there that's investigating the same thing that I'm investigating, because that's a really great way to have someone come along and go, oh no, there's this whole scholarly community that you completely missed. But what I will say is that I can't find any scholarship that is asking the question that I'm asking. When scholars look at jury instructions, they look at how those jury instructions affect the jury. And that's a really important question for us to sort of wrap our heads around, because the jury is sort of the target audience for those instructions. But a lot of what I find is that there's some argument over the jury instructions proceeding, and then the case settles. So there's something in these instructions that's communicating something actually to the litigants. And that's where my interest lies, is in the communication between the disputing parties and the court as to sort of how to evaluate the case and how to try and negotiate a settlement out of the case. And that's the piece of the puzzle that I can't find any prior work on.
So maybe you could sort of talk a little bit about why the sort of negotiation over and decision of what the jury instructions should look like are such a sort of unique moment in a civil trial. And sort of because of that, what kind of information might they communicate, or how might the jury instructions, once promulgated, affect the incentives of the parties?
Yeah. So when we look at the litigation process, there's sort of two major models that talk about how the parties kind of reach a conclusion as to how the case ought to resolve. One is that one party has some information that the other one doesn't, right? And that's called, perhaps somewhat obviously, an asymmetric information model. The other model is that they have the same set of information, but they evaluate it differently. Okay, and so they look at the facts and the law that are relevant to the case, and the defendant goes, I think I've got a 40% chance of winning, and so I'm going to settle based on how I calculate the damages with a 40% discount. And the plaintiff looks at the facts and the law and says, I have a 20% chance of winning. I'm sorry, an 80% chance of winning. And so I'm going to negotiate a settlement based on my calculation of damages at a 20% discount. So the idea is that based on how likely they think they are to win, plaintiffs and defendants are willing to settle at a discount based on what they think the value of the case is and the likelihood of victory. The point of jury instructions is that this is an opportunity for the court to shape those expectations by saying, this is how we describe the law. And so the lawyers in the case are able to take those statements of law and use them to say, okay, based on this, this is how the jury is going to evaluate the evidence that we know is going to be important. And that's going to change our view of what we think our likelihood of victory is. And that's essentially the basic theory that I'm working under, is that these guys are able to take the information that's coming out of the court and use it to update their priors. And that's an important term that I use, although I didn't do it in the larger project that this is a piece of. This project is probably going in the direction of a Bayesian analysis, where you take past information and you use new information to change your evaluation.
Mm-hmm, mm-hmm. Yeah, I mean, it struck me as one of the ironies of the perspective you're taking on jury instructions is that, in a way, they're communicating at least as much, if not more, information to the lawyers than they are to the members of the jury.
That's absolutely right. I think that, if we look at the prior literature, looking at how juries evaluate their jury instructions, what we see is an awful lot of work that suggests that they don't really understand what they're being told. And the dangerous part of it is that if you ask them how well they understand the instructions, the juries think they've got it down cold.
It's like Dunning-Kruger for the win, huh?
Right, and so, we're faced with a situation where the people who are supposed to understand this stuff don't, but think that they do, and are using it to resolve these disputes and engage in authoritative distribution of resources. And so I think it makes a lot of sense for us to look at jury instructions and go, well, what do the litigants think about this? Because if you get a jury instruction and you look at it and you go, 12 knuckleheads from rural wherever are not going to understand this, you're going to be really interested in making sure they never get a chance to misunderstand.
Yeah, no, that makes a lot of sense. So the paper's based on an empirical study, which has a lot of interesting factors and facets built into it. So I wonder if you could describe the study a little bit. What was the data set? Where and how did you get the data?
Sure. So this project is part of my larger dissertation, which relies on data from the EEOC litigation project. And the EEOC litigation project is this fantastic data source that was compiled by, Pauline Kim, Margot Schlanger, and Andrew Martin at Washington University in St. Louis. And I cannot praise them enough for having the foresight and the capacity to build out this data set and to convince the National Science Foundation to fund it, to allow them to compile it. So that this is a fantastic data set for anybody who's studying trial courts and trial court litigation processes. But it's missing a couple of pieces of the puzzle. Specifically for this project, it doesn't have anything about jury instruction proceedings. So what I did was I reached out to 93 of the 94 district courts, because there's one district court, I think the U.S. Virgin Islands, that has no cases in the data set. And I asked the chief judges of all of those courts to grant me fee waivers to allow me to access PACER documents for free. And I used those fee waivers to download documents related to the cases that were already in the data set. So the goal was to extend the data set with some additional variables. And unfortunately, There were a lot of courts that didn't respond to the requests for waivers. There were some that denied them. There were courts that granted the waivers, but there weren't any cases where I could download documents that were helpful for the things I wanted to add. So what I wind up with is 80 jury instructions documents across 30 cases that are in 6 different courts in 6 different states. And it's 5 cases from Florida, 3 from Arizona, and then 1 each from 4 other states.
Yeah. So it's a little bit of a tangent, but I hadn't heard of this waiver program before. I mean, how well did that work? What sort of response rate did you get? And like, to what extent were courts open to providing these kinds of waivers? Because this seems like data they ought to want you to have. You're doing work for them.
Yeah. So there's a few courts that just explicitly have policies of not granting these waivers. These are waivers that are authorized but not required by the regulations that implement PACER from the Administrative Office of Courts. So it's up to a chief judge's discretion whether they want to grant these. And so, like, I remember immediately after I sent my waiver requests, I got an email personally from the chief judge of the Western District of Louisiana, who was confused and thought I was asking them to waive fees for all the district courts in the country. I was like, I'm not sure I have the authority to do that. And I had to email them back and say, no, Your Honor, that's not what I'm asking you to do. I've asked all the other judges that are relevant to deal with this. And then in Delaware, they just flat denied my request from the clerk's office, not from the chief judge's chambers. And when I called the clerk to kind of clarify what was going on, because the denial letter talked in terms of, we can't give you a PACER login. I said, well, that's not what I'm looking for. I have a PACER account. I just need you to contact the service center and give me a fee waiver. It turned out that a couple of years ago, a scholar who had been given a fee waiver in Delaware had implemented a document search that was so burdensome that it crashed the filing system. Right at a point when every lawyer who, this was a time when it was like an end of the month or end of a quarter where every lawyer is trying to file something and suddenly the system just goes dead. And so Delaware had implemented an entire policy of, we do not grant these waivers anymore. So those sorts of things absolutely happened. A lot more frequently, what happened was I just never heard back. And, I was a broke graduate student, and so silence was a no, because I couldn't afford to go in and find out if I was getting charged. But I think I got fee waivers from about 35 to 40 different district courts. And some of them wound up not being helpful because, like I said, there weren't any downloadable documents in the cases that I was looking at. And some of them wound up being extremely helpful. And I have all of the documents that I downloaded in a private cloud server, but I can't publish the documents because part of the terms under which these fee waivers are granted includes an order from the court directing me not to republish these documents.
Well, I mean, as response rates go, 40 to 50% isn't terrible.
No, not at all. I'm very pleased by how that panned out.
Awesome. Well, maybe you could describe some of the findings from the study, at least, and I'm not a stats person, but my sense was that there were like some limited quantitative findings and then some much more robust qualitative findings.
Well,
is that right?
I would not I would not describe this as any sort of quantitative findings, because frankly, there just aren't enough observations for any sort of hypothesis testing. What I can say is that I can give you some descriptive statistics, and that's basically that what we find, in the descriptive statistics is that for the most part, courts aren't paying a whole lot of attention to what the parties are arguing over in uh, in these jury instructions proceedings. A lot of what we saw, or what I saw, sorry, I don't have any co-authors. What I saw, a lot of what I saw was courts basically building instructions themselves. So if the parties couldn't reach an agreement, the court would sort of craft its own instruction. And that was far more common than anything else. And frankly, what I saw was a lot of situations where things that were presented to the court sort of got ignored. Um, and I can't, because of the limits on the data, I can't tell if what's happening is these sorts of boilerplate, uh, basic lead off types of instructions, things like what is and is not evidence, whether the judges are giving those instructions to the jury, but just not putting them in the orders where they list out the instructions, or whether they're just not giving those instructions. Does that, I don't know if that makes any sense at all. Um,
Yeah, yeah. So, I mean, from a kind of descriptive or qualitative standpoint, were there sort of some kinds of instructions that were more salient to litigants and some kinds that were less salient? And sort of how did you sort of, to what extent could you sort of model or understand kind of litigant incentives and litigant behavior in relation to the data that you were able to generate?
so basically what I do is I say, okay, we don't really know how litigants see these jury instructions, so let's sort of think off of first principles. And we have this model with a decision maker and sort of disputing advisors, and that model comes out of the public policy literature, and it's not worth sort of going too far down the rabbit hole. But basically, where it comes out in terms of conclusions is that you're trying to balance how likely you are to be reversed if you win with how much greater the probability of victory is. And so that determines how parties contest these jury instructions. Is they're trying to balance the risk of reversal with the reward of victory. And so in order to get down into that, what I find is that the parties kind of set aside things that don't affect the outcome of the case. Things like, what is evidence? What does it mean if depositions are read into the record? What's the role of the jury in all of this? You know, things like that. And I call those procedural instructions that are just sort of laying the groundwork for, ladies and gentlemen of the jury, this is what you can expect in this process. The parties are much more likely to contest what I call merits instructions, which relate to issues that they're actually litigating and disputing. Okay, so all of the cases in this data set are EEOC agency enforcement actions. So they're all Title VII, ADA, Age Discrimination, and Equal Pay Act. And so you got a lot of things about what are the elements of a sexual harassment claim, and conversely, what are the elements that an employer has to prove to put on the Ellerth defense of remediation policies, right? What do you have to prove to demonstrate a failure to accommodate claim under the ADA? And those are the issues that the parties contest. And I find some evidence, and I don't want to oversell it, but there's some evidence that suggests that if a court sides more with one side over the other in contesting merits instructions, that there's a possibility that the jury may find for that particular side.
Mm, mm. So in your paper, you give kind of 3 representative examples of sort of how this played out in practice. And I found those really kind of illuminating and helpful in kind of understanding some of the insights and arguments in the article. I wonder if you could just briefly kind of walk through what those are and what they show.
Sure. I focused on the cases out of Florida, and I chose these cases because there was a defense verdict, a plaintiff's verdict, and a settlement among all 3 of them. And the paper kind of talks about the methodological concerns related to selecting on the dependent variable. If your listeners are interested in that, please read the paper. But basically, I've got a case where the parties argued over everything, it seemed like. That's the Rio Bravo case. And at the end of the day, the court adopted most of the defendant's instructions on the procedural issues and adopted the plaintiff's instructions on the merits issues. And I apologize in advance. There's a thunderstorm going overhead, so if you're hearing cracks and booms, that's why. So the court sides with the plaintiff on the merits issues, and then the jury awards over $300,000 per employee. And then we have this case where the judge sort of mishmashes a lot of stuff, and that's the Pacino's case. And there's not really a clear winner on the merit side. And the parties actually reached some agreement on some issues, but they contested a lot of things. And that case settled. So we don't have a clear winner in the jury instructions process. The parties kind of look at the jury instructions, I surmise, and they go, we don't know how this is going to come out. Let's settle rather than run the risk of losing. And then the last case that I have is the FLTVT case, where the judge basically sides with the defendant on everything. And at the end of that case, the jury rules in favor of the defendant. And that to me is that narrative is what sort of informs the empirical conclusion that I'm suggesting at the end of the paper. It may be appropriate to test further. One of the things that I think divides political scientists and the legal academy is, in the legal academy, these 3 case studies, there are people out there who would say, you've proven your theory. In political science, this approach is taken as suggestive rather than conclusive. And this is a conversation I've had with law professors on several occasions.
Yeah, no. It seems like it's at least consistent with your thesis, but maybe there are alternative explanations as well, and you just maybe don't have enough data yet to say conclusively what the meaning of the evidence is.
That's exactly how political scientists would talk about it. And I mean, I've had this conversation with law professors on numerous occasions. They say, I don't need statistics. I've seen it happen. I know it happens. And that's enough to prove to me that it happens. And so it's a different method of generating knowledge.
Well, so Reid, in closing, I wonder if you could talk a little bit about how this project fit into the broader dissertation project of which it's a part, and also sort of where you see this particular project going in the future. Because it seems like a really kind of provocative new way of looking at jury instructions with seemingly a lot of promise for, kind of potential future studies and interventions.
Absolutely. So in terms of the dissertation, the idea behind the dissertation was that we would look at several different litigation phases and see how does the way that the parties contest those phases affect whether the case settles and how much plaintiffs get at the end of the case. One of the strengths of the EEOC litigation project is that the federal government has a presumption of settling in cases in public. And so a lot of people who study trial courts sort of lament the fact that most settlements are confidential, and this creates concerns that when we look at outcomes, we don't know if what we have is a representative sample. But with this data, with very few exceptions, even if the case settles, I know how much the plaintiff got at the end of the case. And so I'm able to actually compare payouts between cases that settle and cases that go all the way to a verdict. And so I look at how pleadings affect those different sorts of outcomes. I look at motion practice. I look at summary judgment specifically, and I look at jury instructions. And the findings are a little all over the place. They're difficult to sort of sum up in one or two sentences, but the best I can come up with is that there seem to be a couple of breakpoints for settlement, places where the case is likely to settle. And then there are some case characteristics that tend to increase payouts, and a lot of them are things that I think are sort of intuitive, right? Cases with more plaintiffs have higher payouts. Cases involving higher status employees get higher payouts because there's more back pay at issue. Those sorts of things that don't necessarily surprise us that much. And as far as where I'm going to take the project in the future, I've identified 6 different pieces that I think can be mined as articles, including this one. And then I've actually had a little bit of interest from book publishers related to this article in particular. So I don't know. I don't know yet if the publishers are interested in the project that's already done, or if they're interested in a new project that's focused specifically on jury instructions. So we'll kind of see how those meetings go. I've got one scheduled this weekend at the American Political Science Association.
Great. Well, it sounds really exciting, and I can't wait to see what you produce next on this project. And thanks so much for coming on the show, Reid.
Well, from your lips to God's ears.
Take one.
Quiet, please. Recording.
I go again. I found a way to cook.
Take 2.
I found a way to cook extra. Come on over and try my crispy. It's entirely different, and yet it's just as tender and tasty. No, and it's just as finger-licking good. You see, I found a way to cook chicken deep down and get that real crispy crust that some folks like. And it's just as tender and juicy, and I'll get it now. I found a way to cook chicken deep down and get that crispy, real crispy chicken crust. Yet it's entirely different. No.
This will be wild lines 30. Take one.
Now you have two kinds of Kentucky Fried Chicken.
Start again.
He said cut it.
Go ahead.
And now you have two kinds of Kentucky Fried Chicken to choose from. Yet tender and juicy. Is that it? Yeah.
That's all right. Cut it.
It's better,
Take two.
Colonel, if you read it. Okay, we're recording.
Now you have two kinds of Kentucky Fried Chicken to choose from. My regular recipe.
Take three.
It's entirely different. But every bit. Yes. Now you have two kinds of Kentucky Fried Chicken. Let me get that scratched off of there and quit looking at it.
Quiet, please.
That real crusty, what kind of damn crispy crust. It's really different. Now you can have two kinds of Kentucky Fried Chicken to choose from. My regular recipe and my new extra crisp.
Crispy.
New extra crispy. I thought I said that. Now you have two kinds of Kentucky Fried Chicken to choose from. It's entirely different. Yet every bit is finger-licking good, you see. No, every bit of it's finger-licking good. You see, I found a way to cook chicken deep down to get that real crispy crust some folks like. I better do that again, huh?
Yes. All right. Cut.
You don't want me to sing, do you, for Christ's sake?
We're rolling. This is the good one. Take 5.
Most folks
All right, once again.
most folks have heard about.
All right, that's good. Good, very nice.
That's why folks call it finger.
Sounds good.
That's why folks call it finger licking good. That's why folks call it. That's why folks call it finger licking good. That's why folks call it finger licking good. I'm not getting anywhere with this damn thing.
Okay, fine.